All right, so today I'm going to be talking about comparative fault. What is comparative fault? How can it affect your personal injury case? And many other details. So, first of all, in personal injury, the defense is going to try and look for each and every way to not pay as much for a claim. So, comparative fault is one of those options. You have several different options, whether you blew statute of limitations, or there are other people that are also negligent besides the defendant, so there could be some kind of apportionment of responsibility. We'll get to that in another video. But then you have comparative fault, which is one of the many options to try and lessen the amount of the defendant's exposure. So what's comparative fault in California? Essentially, it's fault placed on the plaintiff for the negligence, for the damage that's caused from whatever kind of accident. So let's say you're in a car accident, the defendant runs into the plaintiff while the plaintiff has stopped at a red light. It's going to be very difficult to find any comparative fault there. But let's say, the plaintiff was speeding and the defendant also caused the accident. There could be some kind of way to say that obviously, had the plaintiff not been speeding, then perhaps the accident would not have been caused. So perhaps the plaintiff is somewhat responsible for their injury. Or let's say, in a slip and fall, the plaintiff didn't exactly look where they were going, so maybe their negligence partially caused the accident. So what does comparative fault actually do in a personal injury setting? For purposes of trying to settle the case, the plaintiff's attorney and the defense attorney probably will be discussing this comparative fault. Plaintiff's attorney can either accept the defense attorney argument or not and proceed to trial if they can't come to some kind of resolution. So in the trial, the comparative fault setting actually appears on what's called the verdict form. So the jury is going to go and decide and put a percentage of fault on the plaintiff. So let's say you get a verdict and judgment for $1 million, a verdict for $1 million, but the plaintiff is 50% at fault because either they didn't look where they were going or they were just negligent in some kind of way that ended up causing the accident. That will limit the amount of the judgment and potentially the recovery that the plaintiff will have against the defendant. So comparative fault is an extremely useful and tool for the defense, and something that plaintiffs obviously want to avoid if they can, obviously to argue against it, to say there's no evidence to point to defense's argument that the plaintiff was at fault for this injury. But if the plaintiff's name or their fault percentage appears on the verdict form, then that could be it could be risky for the plaintiff. I mean, going to trial in general is risky, but if the judge believes that the plaintiff is at fault, that could be an even higher risk to allow for the comparative fault setting to be on the verdict form. So there are even situations where the jury could come back and say that the plaintiff is 99% at fault or 100% at fault, and essentially that could, essentially result in a defense verdict, or just giving the defense such a low exposure that it essentially just could be compared to a defense verdict. So comparative fault, if the plaintiff is at fault for the injury, then they should probably heavily consider whether or not it's worth going to trial because of that added risk. Obviously, if the parties cannot come to some kind of an agreement, then the plaintiff most likely is going to be better off going to trial if the costs, if the benefits, potential benefits outweigh the potential risks involved. So that's it. If you guys have any questions about comparative fault, please let me know, and I will talk to you soon.